Good day, ladies and gentlemen, and welcome to your remaining nonpartisan in an increasingly partisan environment webinar. All lines have been placed on a listen-only mode, and the floor will be open for your questions and comments following the presentation. If you would like to submit a question at any time during the webinar, you may use the chat box located on the lower right-hand side of your screen. Simply type your message into the box and click on the send button. If you should require assistance throughout the conference, please press *0 on your telephone keypad to reach a live operator. At this time, it is my pleasure to turn the floor over to your host, Kay Warnock. Ma'am, the floor is yours.
Thank you for joining us today. The Legal Services Staff Section and the Research and Committee Staff Section would like to thank the NCSL Foundation for State Legislatures for providing an e-learning grant to produce this webinar. I'm pleased to announce that over 150 legislative staff from 32 states are participating today. As always, we will save an archived copy of the webinar and a PDF of the slides on the NCSL website within the next week. Legislatures are created by partisan minds coming together to create bipartisan solutions. Our speakers today come from two different environments. One comes from a legislature that is controlled by a single party. The other from a legislature where each of the major parties controls one legislative chamber. They are Thomas Vaughn, Associate General Counsel, Office of Legislative Research and General Counsel in Utah, and Rochelle Yelmus, Senior Legal Counsel of the Legislative Services Agency in Iowa. Their full bios are located on the NCSL website for your review. I'll turn it over to you, Tom.
Thank you, Kay. I hope everyone can hear me okay. I just want to start out by introducing our topic a little bit. Rochelle and I will be presenting different portions of this webinar. There have always been challenges to staff who are nonpartisan when we're functioning in a legislative environment with clients who very clearly are partisan. Their plans and their positions are very important to them. And again, as I said, while we are not partisan, they clearly are. I often say that I have 104 bosses. They all have a different opinion, and they're all right. And I like them to all feel that they're right. I've noticed a trend in the last few years that partisanship has been increasing. This has been in the national news, but I don't think it's just a national issue. I think it's happening at the state level, too. And as a result, the pressures on nonpartisan staff to break from their obligations of nonpartisanship have increased. The purpose of this webinar is to discuss some of these challenges and suggest methods of dealing with the challenges so that we can maintain our credibility as nonpartisan staff. As Kay mentioned, Rochelle and I do come from different types of legislatures. Utah's legislature is predominantly Republican. 82% are Republican, and the Republican Party controls both houses. Her legislature is a lot more evenly divided, and I think while we have some of the same issues, there are some things that are different between the two of us because of that different makeup. I wanted to just briefly discuss how our presentation is going to go. I'm going to briefly start talking about the difference between nonpartisanship and bipartisanship. Rochelle is going to talk about the benefits of nonpartisan staff to the legislatures. Then she is going to go into a section on Iowa's perspective of remaining nonpartisan, some of the challenges that they face in Iowa and the ways that they deal with those challenges. I will do the same thing for Utah following her presentation. I will end the presentation then by talking briefly about relationships between legislative attorneys and non-legislators, and then we will have some time for questions. So let's go ahead and talk about the nonpartisan versus bipartisan. Sometimes I've heard people use these terms interchangeably. I think that's a mistake, and I think it's important, and I'll discuss why. Definition of bipartisan from Merriam-Webster's dictionary is of relating to or involving members of two parties marked by or involving cooperation, agreement, and compromise between two major political parties. The definition of nonpartisan, however, is not partisan. That's kind of a no-brainer, but then the rest of it, I think, helps more. Free from party affiliation, bias, or designation. Some of the synonyms for nonpartisan, also from Merriam-Webster, are candid, equal, equitable, even-handed, impartial, just, fair, objective, unbiased, and unprejudiced. Why is this distinction important? Well, I think first of all is because it recognizes that there are factions or interests within and across party lines. It's not just Republican or Democrat or other parties. Within those parties and even across those party lines, you have people who would characterize themselves as liberal, moderate, or conservative. You also have formal and informal caucuses that are within the legislature that are based on different ideals, philosophies, issues. Could be geography, such as rural districts versus urban districts. And oftentimes we can have the House versus the Senate, where they're not thinking along the same lines. I think one of the reasons the distinction is important is it helps you remember who your client is at different times. And as we all know, that can be different groups or different people at different times. Understanding the distinction focuses staff on what your goals as a member of legislative staff should be. It's not to further the interest of a party or parties. Though we end up representing people from both parties, we never represent the party. Also, it focuses on helping our client, whoever that client may be at the time, in fulfilling their client's goals without actually advocating for those goals. And we'll talk more about that in a moment, but I will now turn the time over to Rochelle.
Okay, thanks, Tom. And just waiting here to get control of the PowerPoint. Tom, do you still have that in your possession?
I do not.
I do not. Oh, okay. Sorry. There we go. Okay, so as we get started today, I'd like to reiterate that much of what Tom and I will be talking about relates generally to nonpartisan legislative staff. However, my comments where I specifically talk about some of the challenges faced today relate specifically to my own role and experiences and some of my colleagues' experiences as nonpartisan legislative staffers who are attorneys serving in our LSA here in Iowa. So I just want to point that out. So some of the benefits of I'm going to speak briefly about some of the benefits of and advantages of nonpartisan staff that I see to serve the legislature. I'd like to begin by noting that the focus of our work here in Iowa as a legislative services agency is on providing nonpartisan staff services to all members of the General Assembly, which includes services related to committee staffing, legal drafting, budget analysis and research, and computer technology support. The focus then is not on providing strategic public policy advice through any of these services. We have a statutory obligation under our Iowa Code Chapter 2A to provide work products and our services to support our legislative members in a neutral and objective manner. And we are specifically, by statute, prohibited from making public policy recommendations. Therefore, one of the very basic core advantages that I see of nonpartisan staff is that our staff cannot and is not competing to persuade our legislative members to take certain public policy positions in an environment where almost all other legislative stakeholders are really trying to do just that. While we may at times be asked by members to lay out possible options and compromise language specifically relating to what we do when we draft, for example, which we often do, our focus is not to convince members to ultimately adopt a particular policy position for any particular political gain. And our jobs are not dependent upon how well we do that. What our jobs are dependent on is how well we provide our services in an objective, discreet, and candid manner. To each and every one of our, here in Iowa, 150 clients, 150 legislative clients, independent of our own personal beliefs and biases or third-party interests. This is important because the manner in which we carry out our professional obligations to serve our members in a non-biased and neutral way, I believe, serves to foster an environment of trust and respect in and for the work we do on both sides of the aisle. And this is crucial to who we are and how we define ourselves as nonpartisan staff. Another important benefit of nonpartisan staffing that I see is in our potential as a professional staff to preserve the institutional knowledge or memory of the legislature. And I would like to point out a statistic that is important to this point based upon a 2006 NCSL legislative staff survey conducted by Mr. Carl Kurtz, which reported that partisan staff have substantially less tenure in the legislative service than do nonpartisan staff. His survey showed that approximately 2/3 of nonpartisan staff had been in legislative service for 10 years or more. This concept of preserving institutional memory has taken on more significance. Can everybody hear me?
Yes.
Okay. I'm sorry. We are having a fire drill right now, so I will continue. Term limit. So this concept of preserving institutional memory becomes really important in our era of term limits, which has resulted in higher levels of legislator and partisan staff turnover. Nonpartisan staff often have the benefit of longer staff service and really not as steep of a learning curve at the beginning of each new session. And this helps to preserve what has happened, the legislative history, over the course of several legislative sessions with regard not only to particular issues, but also with regard to how things are done, certain procedures, although we are not the procedure police by any means, as we remind our members. I see this as a benefit. It aids us in providing our services more efficiently in a work environment that we all know is often very fast-paced and demands that things get done yesterday. I also think this is important because it allows us as nonpartisan staff really to be more proactive rather than reactive regarding a particular problem that might arise in our work environment because we have had that prior experience, and it helps us build those important skills, really of skills that we really want to focus on, of being more responsive, resourceful, and efficient in for our legislative members. Before I provide specific examples of challenges I have faced and my colleagues have faced as nonpartisan legislative staff attorneys working for a nonpartisan legislative services agency here in Iowa, I'd like to take a few minutes to provide you with some very basic information about our political environment. Tom spoke briefly about this. I'd like to expand on it just a little bit, and our legislative staff structure to give you some context about our work environment. Unlike Utah's, Tom already told you about, Iowa's legislature does not have a clear majority of one party in both houses. We have what's known as a divided or split legislature, and it's been that way for the past 4 years. We have 150 legislators that we serve, 50 in the Senate and 100 in the House. And our Senate is controlled by the Democrats by one senator, 26 to 24, and our House is controlled by the Republicans by a 53 to 47 margin. The control of either chamber could change before the 2015 session, and there could take control of both houses. And we currently have a Republican governor. Each of our houses has they have a partisan caucus staff serving their members, and they also have our centralized, us, Legislative Services Agency, serving them to provide our nonpartisan staff services. Just to give you some background about who we are and how we're structured here in the LSA, we're made up of our administrative, computer, fiscal, legal service divisions, and our legislative information office. I am told that our LSA structure is somewhat unique in that all of our divisions serve under just one single overall director appointed by our Legislative Council. And our council is our executive committee of the General Assembly, made up of legislators. It's bipartisan, and those legislators, some of those legislators are leadership legislators and some are not. And it's been that way for us since 2003, serving under a single director. In total, we employ about 83 nonpartisan LSA staffers full-time, and our staffing structure is set up in such a way that it is free from political influence relating to the recruitment and hiring of persons with political agendas or at the urging of a particular legislator or either party. And we are hired, promoted, and terminated by our director subject to council approval. Here in Iowa, as in most states, we have certain laws and guidelines in place that emphasize that the foundation of our role here serving in LSA is to provide nonpartisan services, expressly emphasizing our professional commitment to impartiality. As I mentioned previously, under our Iowa Code Chapter 2A, our core nonpartisan function is contained within that chapter, and specifically within code sections, subsections, or code sections 2A.1 and 2A.4. Under the law, our Legislative Services Agency has a statutory obligation to provide services to the General Assembly in a manner to preserve the authority of the Senate and the House, to determine their own rules of proceedings, and to protect the legislative privileges of the members and employees of the General Assembly. In providing services, we have the obligation to adhere to all policies the General Assembly produces relating to public access to legislative information and confidentiality restrictions. And I'm going to talk a little bit more about our confidentiality policies just shortly when I talk about some of the challenges that we've faced. Our code also expressly prohibits the director and all of our employees of the Legislative Services Agency from participating in partisan political activities and from advocating or opposing issues that are subject to legislative debate. This is reiterated again in a very specific provision relating to our delivery of legal and legislative analyses, and we are prohibited from public policy recommendations. So, with all that background, I would like to move into challenges that I have faced and my colleagues have faced relating to bill drafting. So my challenges are very specific to the bill drafting duties that we have serving as nonpartisan staff in our legal division. So just because we have nonpartisan staff structure in place and guidelines and actually statutory obligations, it does not mean that our nonpartisan staff are not subject at times to political pressure to deliver our work products and our services to benefit a particular legislator's agenda or a party position. This does happen. These pressures are very real and have occurred in the past. Here are some situations my colleagues and I have faced relating to our bill drafting duties, as I mentioned before, and the guidelines we have in place and use in responding to those challenges. The first specific example I'd like to share relates to bill drafting priority and deadline concerns. This specifically relates to a situation where a concern has been raised by a particular legislator or by another stakeholder that another legislator or party's bill draft request is receiving preferential or priority treatment in the drafting process. Our response is to educate our members that our Legal Services Division generally applies certain bill drafting prioritization guidelines based upon but one of the categories that we look towards is how we categorize the bill by sponsorship. So in other words, does the request come in from an individual legislator, from an interim or standing committee, from leadership, from an executive branch agency, or from the governor, or from the judicial branch? These are all the different entities that we draft for during session. The other factor that we look at is when the bill draft was received. Did it come in prior to session, the beginning of session, or during session? And just to give you some examples of our prioritization guidelines that we have in place here, prior to session, executive and judicial branch requests, which really have the earliest request deadlines, and when I say request deadlines, I'm talking about deadlines put in place through Legislative Council rules. Those are given priority in order to have what are usually executive and judicial branch bills are, I shouldn't say usually, oftentimes relatively non-controversial, and to get those bills ready for committee consideration at the beginning of session. Immediately prior to session, a governor's bill draft request is due, and in most years when those requests come in and they're relatively few in number, they are given priority in order to have those ready for committee consideration as early in the session as possible. Now, prior to and at the beginning of the session, standing committee chairpersons' bill drafting requests are given priority, as most of these requests, we know, will receive committee consideration, and they need to be presented to the committee as early in the session as possible. Leadership requests are given very high priority, but we tell legislators that they do have the option of submitting a pre-file request prior to the beginning of session, and those requests do receive priority drafting consideration, and we make every effort to get those bills drafted and back to the legislator as soon as we can. Individual member requests that are submitted once session has begun are generally handled in the chronological order in which we receive them. That's what we tell our members. But we also do tell our members, and we tell all of our members, that insufficient drafting instructions and incomplete decision-making by a requester can prevent them from getting their bill as quickly as they'd like. So those are some of the guidelines we have in place, and we educate our members when that concern comes in, but it does come in, and that's how we deal with that concern. Another challenge we've faced on occasion is being asked to draft a bill that we have some constitutional concerns about. Oh, sorry about that. Upon the request of a legislator that a bill, we believe, based upon our independent and professional judgment and legal training, is of doubtful constitutionality, we as drafters have an obligation to talk to the legislator about the likely basis for the challenge if they're not already aware of those concerns, and oftentimes they are aware of those concerns, and they might want to proceed with drafting the bill for reasons other than having the bill officially introduced and work its way through the legislative process. They may want to do that to satisfy a constituent, or they might have other reasons, and sometimes they are very well aware that the bill would, as drafted, as requested, would face constitutional challenges. We also tell the legislators that if others ask questions about challenges, we give the same advice to everybody if that bill is public and out there and has people are aware of the bill. We also try to draft the bill in a manner, if they want to proceed with the bill, they intend on moving the bill through the legislative process, we offer them the option of drafting the bill in a manner that accomplishes their purpose, their intent, which is constitutional, and not trying to change in any way the focus of the bill, but offering them that option. I'd also like to note that we document our discussions and our advice with our legislative sponsors who request these types of bills, and we are very specific about actually writing, myself, I write a memo to the file so that there is a very official document about the discussions and the fact that the legislator did want to proceed very specifically with the bill. Okay, a third challenge we've faced in respect to our bill drafting duties relates to confidential bill requests and being asked about either the existence of or the actual contents of a bill prior to the bill's introduction. I personally have been asked about this by members of the same party and the same staff, by opposing party members, by outside agencies, and other stakeholders, including lobbyists, about, hey, does that bill exist, and can you tell me where the bill is in the process? Sometimes, can you tell me very specifically about what that bill says? So that's been a challenge for us as well. In response to this, I'd like to take a minute to talk about the nature of confidentiality and what it means for us in the environment, and why this is important to our role as nonpartisan staff. In providing services to the General Assembly, our agency is required, again, by statute under Iowa Code Section 2A.1, subsection 3, to adhere to all applicable policies relating to public access, again, I'm repeating, but to legislative information and related confidentiality restrictions. Our division operates and provides our services in this environment where individual and confidential working relationships are formed, and with each member of that, legislative member, and oftentimes, if we get the consent of the member, with the member's agents. And when I say agents, I'm talking about partisan staff, personal staff, constituents, lobbyists, and other stakeholders. Again, as nonpartisan staff, we form the same type of working relationships with all members of both parties. So what parties do we have here in Iowa in our LSA in place to protect those confidential relationships, specifically in a situation like this? Our Legislative Council has adopted a confidentiality policy for our Legislative Services Agency, which covers bill and amendment drafting files, and that policy generally provides for general confidentiality for all amendment drafting files and limited confidentiality for bill drafting files. So when a bill request is made, we categorize that bill request as either confidential or non-confidential. And when we get a question about whether a particular bill request exists, our specific policy is that a bill request will be public information, meaning that the working title with the name of the sponsor will appear in the public log posted on our public website unless the sponsor specifically designates the bill request as confidential. If a bill request is categorized as confidential by the sponsor, the bill title and the sponsor name will not appear on our public log, and the bill will not be submitted for a fiscal analysis. Now, this designation as confidential does not stop a sponsor from designating certain agents, again, I talked about before, to have access to the bill to provide background information and drafting help for drafting purposes if we get specific consent and approval from the sponsor, and that specific consent is documented on the bill request itself or in the drafting file. In conclusion, in concluding this portion of my presentation, I just want to note that relating to this issue of the importance of confidentiality in providing nonpartisan services to our legislative members also raises the issue of who we are serving when we provide those services. The question is, are we serving the individual members or the legislature as a whole, or both? As I talked about earlier, our statutory obligation, as expressly stated in our Iowa Code Section 2A.1, subsection 3, talks about the following obligations that we have, and that is to provide services to the General Assembly, to preserve the authority of the Senate and the House to determine their own rules of proceedings, and to exercise their powers as a separate entity of the General Assembly. This specific language describes services provided and points towards the institution of the legislature as the client. We also, in that very same statutory provision, have language that we are obligated to protect the legislative privileges of the members themselves, and this obligation really points towards the members as the client of the services. Our model code of professional responsibility adopted by our Iowa Supreme Court recognizes attorney practice in a multi-client environment such as the legislature, and that a legislative attorney may represent, quote unquote, individual legislators, legislative committees, and the legislature as a whole with single or numerous interests that might be conflicting. So our model rules provide that in this regard, a legislative attorney must be first and foremost concerned with, again, like I just spoke about, fully disclosing all interests to all clients and securing the consent of the multiple clients to continue representing those numerous and sometimes very conflicting interests. Okay, Tom, I'm going to hand it over to you.
Thank you. Just waiting for the control of the PowerPoint to switch over. Okay. As I mentioned earlier, Utah's got a different or unique setup in that we have a large majority of one party in the same party, the Republican Party, in both houses. It has been that way for many years, and so it's not something where we've had an experience of switching control between parties at any time in the recent past. Because of this, there are some pressures that are unique to that type of environment. There's a pressure to, quote, give in to the so-called political reality that, you know, this is a Republican state, and so if you keep the Republicans happy, then everybody's going to be happy. I don't subscribe to that position, but there is some pressure to that. I'll talk about how we overcome that in a moment. There's a risk that the minority party will feel that they're not relevant from a staff's perspective, that there's, the services are more likely to be given to the Republicans than the Democrats because the Republicans are in the majority. As our office, we bend over backwards to make sure that that is in fact not true, but also in appearance not true, and I'll talk about that a little bit more as well. I'd like to talk just a little bit about our system of priorities. It's a little bit different than Iowa, but I think it helps in both parties feeling that they're treated equal. We have what I believe is probably a unique system in Utah. By legislative rule, we allow each legislator to designate up to 3 of their bill requests as priority bills. If you designate a bill request as a priority bill request, it jumps ahead in the drafting queue above all other non-priority bills, regardless of when they were requested. Now, we do draft priorities. Among priorities, we draft the ones that were requested. Our legislative session runs from the last week in January through the middle of March. It's a very short session. It's only 45 days. The first deadline for designating one of your priorities is, and you can do it earlier than this, but this is the deadline, is the first Thursday in December. The second deadline is the first Thursday in January. And the third deadline is the first Thursday during the legislative session, which is about 10 days into the session. This creates a system that I think really helps us both be and appear nonpartisan, because it doesn't matter where you are in leadership, it doesn't matter what party you're in. When you designate a priority, it gets drafted before all other bills in the order received. The only other priority designation that can be given is by a committee. A committee vote can vote to prioritize a bill, and that also jumps ahead and is a priority bill. I want to talk a little bit more about functioning in a state with a large majority from one party. One of the things that's important to remember is the minority party is still part of the process. Their constituency put them there by voting for them, and it's our job to serve them as much as it is the majority party. Legislative staff members are hired, and this is important to remember, not by a party. They are hired by the legislature. And even though we have a large majority of one party, the body that hires the director of our office and the general counsel for our office is bipartisan. It's made up of an equal number of Republicans and Democrats, and that's been that way for a long time, and that ensures nonpartisanship, even though that particular body, which is called the Legislative Management Committee, doesn't actually reflect the actual percentages within the bodies themselves. Because our bosses are hired by a nonpartisan body, they also have a strong interest in making sure that their staff is nonpartisan, and that really helps to maintain that, both, again, in reality and in appearance. The other thing I'd like to emphasize is I truly believe that being nonpartisan is the most important part of a legislative staff's job description. We have many things in our job description, but if you lose your nonpartisanship or even the appearance of it, you become completely ineffective in our environment. We also work very hard in our office to create a culture of nonpartisanship. It is preached constantly to staff as well as to the legislators themselves. And I believe that if you talk to most Democrats in our state, they will agree that we are truly nonpartisan and that they get just as good service from staff as the Republican Party does. We work very hard on maintaining that. Because of that, legislators from both parties, we've developed this culture. They both expect us to act in a nonpartisan manner. They count on it. We constantly remind them that we are nonpartisan, and we make sure that we communicate equally with all parties, capital P, and with all parties. Again, this recognizes that we've got the political parties, but there are breakups within and across those that are also important groups, and we have to communicate and treat equally all of them. It'd be really easy to fall into the habit of just telling all the important things to the leadership and forgetting that there's another party that needs to be told those important things do as well. We bend over backwards again to make sure that we are communicating equally with both parties. The other thing is we are very strong at sticking to the rules relating to prioritization, relating to confidentiality, relating to how we represent our clients. That way there's predictability. Both sides know what to expect, and they know what they're always going to get. We don't make exceptions. I'd also like to talk about the issue of polarization. I mentioned earlier that this is not just a national problem. The two main parties in the United States, Republicans and Democrats, have clearly become more polarized, and I've noticed it in my practice here in Utah. We have some legislators that just have the attitude of, look, it's my way or the highway, and especially new legislators that don't quite understand how the nonpartisan office system works seem to have that attitude. We try very quickly to educate them so they understand what our role is and what it is not. Legislators always want you on their side, and that will be true of a legislator that is very experienced and a new legislator. I think that you can be on a legislator's side without being partisan. And by saying that, what I mean is they can feel that you are honestly helping them achieve whatever their goals are by making good suggestions to them, giving good legal advice. And when I say making suggestions, I'm not talking about policy suggestions. What I'm talking about is discussing alternate methods of accomplishing what they want to accomplish than maybe the first one they thought of, and letting them, of course, make the decision. If they feel that you're in their corner to help them accomplish their job, you can do that and make them feel like, hey, this guy is on our side, but at the same time, never taking a policy side on something or supporting one legislator's position or party's position over another. Another thing that I've noticed more and more is that we have legislators that just will not accept an opinion of the Supreme Court. They'll say, well, you may tell me this is unconstitutional, but I don't agree with the Supreme Court. I think if I read the Constitution, it's constitutional. So one of the things that I've tried to do is to not characterize something as being unconstitutional. What I try to say is that the courts, this is the opinion the courts have taken on constitutionality, and based on what they have taken, this is what they're likely to do in the future. That may be a distinction that doesn't really matter in the real world, but it matters to the legislator. They may want to challenge the court's opinion. They may feel the court has interpreted wrong. And I don't want to get in a position where I'm arguing between them and the court or on behalf of the court. I'm just telling him the facts of how the court has ruled. Let's see. Okay. I've been told by legislators, only tell me what I want to hear. I want you to come and explain this bill to the committee, but I don't want you to tell me all this stuff about what the courts have said and stuff. I just want you to tell me, tell everybody what my position is. That puts us in a little bit of a difficult situation, and I want to talk a little bit about how to handle those types of situations. One thing is it's important to educate legislators on our role. One of the attorneys in our office described to me an interesting experience that they had where one legislator was trying to accomplish something with legislation. Another legislator wanted to do something different, and of course, that attorney would follow instructions of both those people. So they might draft the bill, but they may draft an amendment to the bill that the sponsor of the legislation doesn't like. You can run into a situation like that where when it becomes public, a new legislator may feel betrayed and feel like, oh, you are working behind my back to help my opponent. One of the ways that we can avoid that problem is to explain to them very carefully what our role is. That our role is to help all legislators with respect to all legislation. We have duties of confidentiality with respect to them, but we're never working for or against them to try to get a bill passed. Then they kind of understand, the light starts turning on that, oh, okay, my concern is not with this staffer. The staffer was just doing their job. If I have a concern, it's with this other legislator, and I need to go talk to them and see if we can work out our differences. So educating them on their role, on your role, is very important. Explaining to them how nonpartisanship benefits them can really be helpful too. Rochelle talked about some of the ways that being nonpartisan is a benefit to the legislature. If you explain to a legislator that even though you're being nonpartisan in this circumstance may not result in exactly what they want, if they understand that if the if the roles are switched in the future and they're in the other position, they're going to be really happy that you're taking that position. And if you explain to them that you will always act in that way, they will begin to understand, oh, I can trust this person. They're always going to give me valid research and advice. They're not going to say something just because somebody wants them to say it or just because I want to hear it. What I'm going to get is the truth without spin. And I think that most legislators recognize that as a great benefit. I talked a little bit already about how you can be on their side without being partisan. You can recognize the legitimacy of their argument or position without agreeing with it. So a lot of legislators like to talk about their position and why they feel it's strong. Of course, I will listen to them and I'll say, yeah, I can understand your position on that. That makes sense to me, without saying I agree with it or disagree with it, whatever the case may be. I think we also need to be active, not passive, in helping the legislator accomplish the legislator's goals. When a legislator opens a bill file request that is assigned to me, I like to talk to them, and one of the first things I like to find out is, how did this come to your attention? Often we'll find out, oh, well, there was an incident that happened with one of my constituents, or no, so-and-so just brought this to my attention as a problem in government, whatever the case may be. Once I understand what the problem is, how it came to their attention, and how they believe it should be solved, I can be active in helping them come up with legislation that's going to accomplish their goal. Now, whether that legislation ends up passing or not is not my problem. I've often told people, my job is not to draft good bills. My job is to draft bills well. They're going to argue about whether it's a good idea, but I'm going to do a good job of doing it. I'm also going to suggest to them, okay, here's one solution you came up with. Let me tell you, based on my experience, other states have addressed this issue this way. Just something else for them to consider. I'm not trying to tell them that's the way they should do it, but oftentimes when I have given them other ideas, they've been very grateful and felt like, oh, this person's really trying to help me succeed, they really helped me avoid a major amount of opposition if I had tried to do it this other way. It's always their call, but I try to help them accomplish their goals. Now, I think you need to have a skill as a legislative staffer, drafter, or staffer of telling people what they don't want to hear. When they say, I only tell me what I want to hear, you're doing them a disservice if you actually do that. But you don't want it to be in their face either. And so some of the things that I have learned over the years that are helpful ways to deal with this are to say things like this. Instead of saying, oh, this isn't going to work because of this and this, I say, I'm always trying to provide you good service, madam or sir, and I don't want you to be caught off guard by people that may challenge your idea. By starting off with a statement like this before I give them the bad news of legal challenges that might happen or so forth, it's not me that's giving them the bad news now. I'm doing them a favor and warning them about bad news that's going to come their way. This makes it a lot less easier, makes it a lot less likely that they're going to kill the messenger. Another way I might phrase that is, here are some ways you can avoid potential challenges, and then I discuss ways to draft a bill that would be constitutional and would still help accomplish what they're trying to accomplish. When I'm talking about the courts, I don't say this is unconstitutional. I said this is the position that the courts have taken. The courts are the ones that have taken this position that it's going to make my legislator mad, so I'm going to give them the blame for it. I'm not going to take the blame for it. And the legislator, of course, can decide if they care about that or if they want to have me drafted in a way that the court may be likely to strike down anyways. I also use disclaimers. What I mean by this is, if I'm told in a presentation, this is what I want you to talk about, in the presentation, I'm still going to say at the end, because it's my job to give you accurate legal advice, I just want to let you know that this is a viable legal argument. However, there are other arguments that could be made and have been made in courts and successfully challenging this, not to say that it would happen in our jurisdiction or not to say that they're correct or not, but I do give them disclaimers. I don't want them to come back later and say, you gave me professional legal advice that this was all okay and it was smooth sailing, when in fact it was not. So I'm careful how I say it, but I do say it. I document things. Here, verb. When I've said something or someone said something to me, I keep a log of it. That way, if they come back later and don't remember quite as well what our conversation was, and they say, but you told me this, I can go back and say, well, actually what I said was this. Sometimes I'll even do that by an email, a confidential email. In order to maintain our relevancy as professional and nonpartisan staff, I think we have to bend over backwards to maintain our professional integrity. To me, that means a few things. I always follow the rules. I don't break them for anybody. I follow the rules. I will tell my clients what they don't want to hear, but I won't rub their face in it. Again, I say it in a professional and a kind way. I will be nonpartisan in reality and in appearance. Again, even if I am reality being that, but it appears that I'm being otherwise, I bend over backwards to make it appear what the truth is, that I am nonpartisan. I will not let something be falsely attributed to me. If a legislator stands up and misrepresents what a bill says, which can happen accidentally or I suppose sometimes on purpose, I'm not going to correct them unless I'm asked a direct question. However, if they said that I said something, I am going to speak up. I will speak up in a way that won't embarrass them. I'll say, excuse me, there may have been a misunderstanding, or I may not have made myself clear. Here's what my position is. I won't let my credibility be damaged by a statement that's incorrect. I will protect my professional reputation. That's something I owe to myself in the office, and all those things above are part of that, but also my honesty, my integrity, my ability to maintain confidentiality. If they can't trust me, they won't rely on me, and then I'm worthless as an employee. Another thing, I will never lie for anybody, and I will not break the law for anybody. I think with all of us, there have got to be some things we decide, this is more important to me than my job. And to me, my integrity is more important than my job. And so I think that's important. And take just a few minutes, talk about relationship between legislative attorneys and non-legislators. As is not uncommon, legislators often ask legislative attorneys to work with lobbyists, constituents, or other stakeholders when drafting legislation. Sometimes that's just to get some input. Sometimes it's you're told to work with this person and do what they want. We've all been in those situations, but I think we need to remember no matter who we're working with or how long or how deep we're working with them, we don't forget who our client actually is. That's who we owe our duty to. I'm having trouble getting the next slide to advance. Oh, here we go. Okay. In this situation, always keep your client in the loop. Communicate with them. Let them know what's going on with the legislation, even if it's just a passing email or catch them in the hall. Communicate with them to let them know what's going on. Don't keep confidences from your clients. I've had people that I've worked with that have said, don't tell legislator so-and-so this, but the real reason I'm trying to do this is this. I will just stop them right there and say, I just need to explain to you my role. I'm not trying to break any confidences, but I cannot and will not keep confidences from my client. They're my boss. If you don't want them to know something, don't tell me. I don't share information that with this person I've been told to work with unless I'm sure I have that authority to share that information. I may have a legislator that has a different agenda than the person they've told me to work with, but they don't want that person to know their full agenda. I'm certainly not going to disclose that. I'm not going to lie, but I'm also not going to share information that I haven't been authorized to share. I'm also going to advise the legislator, raise issues, and discuss options with them. Sometimes this conversation goes like this. Before I will ever feel good about a legislator approving legislation I've drafted that they've had me work with someone else on, I want to sit down with them, explain to them what their bill actually does, issues that it may raise, other options they may have. Sometimes I've had this conversation and said, do you realize that by doing this, this will affect something else in this way? So many times I've had legislators go, oh my goodness, no, I didn't realize that. Thank you for telling me. Fix that, change it. That is the end of my presentation, and Rochelle and I are now open for comments or questions.
Okay, so now we're going to open the floor for questions. So please type your questions in the chat box on the lower right side of your screen, and I will read those aloud to our presenters. So the first question that I wanted to address is one of our participants asked whether or not Iowa has session limits, and I would actually expand that to ask the question of both of you, and are there any kind of bill introduction limits?
The question about session limits, that's in terms of how long our sessions are. We have two sessions in one General Assembly, and so we do have different time periods that the legislature has to meet, and they're a little different. One is a little longer. The second one is shorter than the first one. But yes, we do very specifically have limits. That's not to say that the legislature doesn't sometimes go over those session time limits, and that on occasion special sessions have been called to get business done that maybe wasn't completed. What was the second question, second part of that? I'm sorry.
Bill introduction limits.
We have particular final deadlines that I spoke about earlier, and those legislative final deadlines are actually put in place by the Legislative Council, and that's to help our legislation move through the process as efficiently as possible. So we do have legislative final deadlines throughout the session. Tom, I'll let you. I took way too much time there.
You're fine. Yeah, in Utah, we have an annual 45-day session. I already indicated when it ends, or when it starts, when it ends. One thing that is a little bit unique about Utah is it ends at midnight on the 45th day. There's none of the things with some states where they'll unplug the clock or cover the clock or something. The reason for that is several years ago, a piece of legislation that we passed after midnight was struck down by our Supreme Court because it was after midnight on the last day. So it is a hard deadline as far as when the session ends, sessions and so forth, but that's got to be called by the governor. As far as filing deadlines, we do have those as well. I talked about the deadlines for prioritizing, but we also have basically what I'd call a drop-dead date in the first part of the session, where after that date you can no longer file bill requests. The only exception to that is if, for example, if you're in the House, if the House votes to allow you to open a bill file late, then that will happen. Though it still goes in the priority list, and it's going to be way down the list in getting drafted, unless, for example, the whole legislature says, hey, we need you to do this now for a reason such as budget reasons or things like that. So I think that's pretty much my answer to that question.
Okay, so here's another one. Do you have a minimum turnaround time for drafting a bill? That is, drafting takes X number of hours.
From Utah, I guess I'll start off with this one. From Utah, we do not have a minimum turnaround time. And I think it would be difficult to have that because, as everyone knows, one bill may be really easy to draft. It can be drafted in a half an hour. Another bill may take so much research and so much time that it takes hours and hours and days to get drafted. So we do not have a time. We follow the priority system. We try to communicate with legislators to keep them updated to where we're at in the process, but no fixed.
Absolutely. I would reiterate everything that Tom said. We often do tell our legislative members that if it's a remake or a retread, obviously they'll get their bill pretty quickly, and we can usually be pretty confident of that, delivering the bill. But we don't have any minimum times because sometimes, like I mentioned in my presentation, we may not have enough decision-making information as well as enough information just generally to complete the draft. So we do tell them, you know what, we need more information. There might be a delay, or we need you to have a decision as to which way you want to go in order for us to complete the draft. So.
Okay, here's another question. Do you see the number of requests from legislators going away from your nonpartisan staff and going to specialized partisan staff that they may be hiring? If so, how do you convey to the members the benefit of your services?
Tom, I'll just start out by saying our Legislative Services Agency, we have to draft all the legislation. So the requests, in order for them to proceed through a legislative session, the bill draft, the bill, and ultimately the legislation, it has to come to us. So I'm not sure if they're talking about partisan drafting staffs. It sounds like that's what they might be referring to.
Yeah, just like same in Utah as Iowa, we do not have partisan drafting staff. We may get drafts that people send to us that were partisan, but we have to do all the actual drafting.
Right.
We'll look at their language, but we'll put it in the format that it needs to be for our legislators. As far as the benefits, I wouldn't have a problem with explaining to a legislator that, if they get something drafted by partisan staff, they're going to hear what they want to hear. But sometimes that's not always the best for them. Sometimes they need to hear the good, the bad, and the ugly so that they can make informed decisions and know what to expect as far as opposition.
Okay, so here's another question. How do you respond when a legislator asks you to revise one of your written work products to further a political agenda?
Tom, I'm going to let you take that one.
Oh, okay. Again, I think this comes down to educate. I will educate them on what my role is and what I'm required to do. I will follow the rules. I won't do it, but I will try to explain to them in a nice way why and how that's a benefit to them if someone tries to do the same thing the other way around. I might suggest that if they want something said a certain way, they can always put together something themselves or with their partisan staff that they can publish to argue their point of view, but I can't put that in legislation. It would not be appropriate. And if I continue to get pushback from them, one of the ways we handle that in our office is we refer them then to our general counsel or to the director of our office, who will tell them the exact same thing we did, but sometimes they need to hear it from someone higher up.
And sometimes I might add, so like I mentioned before with drafting bills that, we have some concerns about the constitutionality. If you can, and I think Tom mentioned this as well, in his discussion, we can offer them the option of trying to accomplish whatever it is they're trying to accomplish, maybe in another way that is not partisan like they want it to be. So we try to work with them very directly. We talk with them and try to work with them. So that would be one way of handling that.
Okay, so one of our participants wants to know if you can talk about nonpartisan staff and the use of social media.
Yeah. Rochelle, why don't you go with that first?
I was just going to say, I do know our Legislative Services Agency does have a Facebook, and I can't speak specifically to, I believe it's just for our internal folks. As far as a Twitter, I really, this would be actually, something that I think some of our younger folks in our division could speak to, but I don't believe we have a Twitter or anything like that. So, Tom?
We have a policy in our office that relates to individual use of social media. One of the things that's really important, is impartiality and the appearance of impartiality. If I have a Facebook account or a LinkedIn account or something that has a bunch of political type of statements on it, it's going to damage my credibility. So we're not told that we can't use Facebook, LinkedIn, Twitter, or whatever, but we're told to be very careful in what we post, what we say, because that is available to everyone, including legislators, and it could damage our credibility. Therefore, for example, I have a Facebook account, I have a LinkedIn account. I don't say that I'm a member of a party. I don't say that I support any political views. I don't talk about those. I post pictures of my kids, things like that. I stay out of it, and it's a policy for us to be careful about that.
Okay, so one of the questions that we were asked is, what can an agency do to rebuild broken trust?
I guess I'll start with that one. That's hard. Building trust is a lot of work, but if you lose it, you can lose it in a second, something that you've gained over a long period of time. Gaining it back a second time is even harder than the first time. My first advice would be never lose that trust. But in the horrible scenario where you're going to have to do something major. You're going to have to do some major reorganization or rule change or overhaul or even staffing changes to convince them that you've fixed it. That's the only way in my mind to do it.
So we have another question on turnaround time. What if the bill filing deadline is on Thursday and the member requests the new bill on Thursday morning?
Okay, and I can speak to so the bill filing deadline. So there's just a short window of time, and you're talking about a deadline where everybody is waiting for the bill, I'm assuming, to get done. We would make that a priority, and we would work just as fast as we could. And I'm assuming this is during session to get that bill done. So I may not be understanding the very specifics of the question.
From my perspective, if the deadline's Thursday and they open it Thursday morning, that's just the deadline for filing a bill request. It's not the deadline for when it can be introduced for Utah. It can be introduced at any time before the end of session. So I just get working on it in my queue as quick as I can and get it done as quick as I can. They understand that if they file it late, it's down at the end of the queue, and they're running a risk that it may never get drafted in time for it to really get a good hearing unless they've got a lot of political clout once it's drafted to move it through the process. And when I say political clout to move it through the process, not clout with us, I'm talking about clout with the bodies themselves, being able to talk the rules chair and pushing it through and getting it up on the board, that sort of thing.
Okay. What is your working relationship with nonpartisan staff outside of your legal division? And do you have specific policies relating to the sharing of confidential information between divisions?
I guess I'll start off with that one. I think our office has a very good relationship with the partisan staff that works for the legislators as well. We have our rules of confidentiality, and we follow them. We're not going to share things with partisan staff unless we've been given authority by the person to whom we owe the confidentiality obligation to share that information. And so we're very careful about that, and if there's any question, we verify it with the legislator first. I don't know that I can say there's a formal written rule about this, specifically how I interact with them. It's just our general rules about confidentiality and about keeping our clients' trust.
And I think the other part of that question was how we share information with nonpartisan staff within our own agency. And we always, again, like Tom said, we go back to getting a sign-off and getting consent on the part of the legislative sponsor to even being able to work with other divisions because our confidentiality provision is very specific to the legislator, and that working relationship is very specific to the legislator. So oftentimes, if we know there might, for example, be a fiscal impact, we might contact the legislator and say, do you mind if I work with somebody? But we get that very specific consent, and we document that consent as well.
So here's a follow-up on the confidentiality questions, actually several. Do non-attorney staff also have to be required to maintain confidentiality with amendments or other legislative documents?
I can speak from Iowa's perspective. Yes, that confidentiality, it's different types of confidentiality, but there is a general express language in our statute that creates our agency that relates to all nonpartisan staffers relating to maintaining confidentiality.
Yeah, they have the same obligation as us, and one of the ways that we try to structure it, though, is that the analysts and the attorneys in our office are considered equals. Nobody's above the other one. However, when it comes to an attorney-client type of privilege, the analyst in that situation would be considered our staff for professional conduct reasons, the rules of professional conduct, in that since they are our staff for legal purposes, the confidences that we have, they also have that obligation, and we have an obligation as attorneys to make sure that we're supervising that aspect of it. So we are not their supervisors, but when it comes to maintaining the attorney-client privilege, we do have a responsibility there that is also passed on to them.
So in relation to that, if the confidentiality to a member is actually between the office and the member, can the attorneys within the office share information about requests?
We can between attorneys. However, I'm very careful that if I'm talking to another attorney about something that is a confidence, to make sure they're aware that that's a confidence, so that they don't share that and think it's public. So we look at our office as a law firm, and therefore we're sharing things. The only circumstance where that doesn't take place is if there is a weird situation where we've got to create a wall where some attorneys know what's going on with something and some don't. Under the rules of professional responsibility, there have been some circumstances with ethics complaints and so forth where we've had to do that. But other than that, no, we will share them with each other, but we will maintain the confidence within the office.
Okay. So that pretty much concludes most of our questions. We do have one request from one of our participants. They'd like to know if they can get copies of each of the state's priority lists to use as a reference.
I've actually already forwarded, and it should be posted on the site within a few days, a copy of the rule from Utah about the priorities, the legislative rule. So that should be available on the website. And
Kay, I can provide our general prioritization guidelines that we operate under, as well as some council rules relating to our pre-file rules.
Great. I'll post those on the website along with a copy of the presentation and a copy of the PowerPoint slides later this week. Are there any other questions before we close? Thank you very much for your time and attention.
Thank you. This does conclude today's conference call. We thank you for your participation. You may disconnect your lines at this time and have a great day.